Number 97.
Ready for court, please?
Counsel, you want rebuttal time?
Yes, 5 minutes, Your Honor.
5 minutes. Go ahead.
Good afternoon, Your Honors. Erica Horwitz from Appellate Advocates for Appellant Teofilo Diaz. Certain fundamental principles of law govern criminal trials in this state, including the bedrock constitutional principle that a defendant has an absolute right to testify fully about what happened at the time of the crime, including his thoughts and feelings.
In this particular case, does the prosecution have the right to notice that he's going to make this kind of an affirmative defense?
No, Your Honor.
Why not?
Well, the plain reading of the statute primarily because the reading that the people advocate would violate a defendant's right to testify on his own behalf.
Does the statute talk about expert evidence?
No,
or just evidence?
The statute refers to psychiatric testimony, psychiatric evidence, and we say that the line is drawn between it should be given its commonly understood meaning.
What about our Burke decision? I mean, that makes pretty clear it applies to any mental health evidence to be offered by defendant in connection with such a defense.
Yes, and mental health evidence should be interpreted, we say, as evidence offered by a mental health professional, not by a defendant like Mr. Diaz, who had a very...
I thought this decision was indicating that there's a dual purpose to the notice provision. It's to allow the people to prepare for whatever is going to come up in the EED defense and to avoid surprise at trial.
Yes,
so
but
how are both of those aims served if we wait until trial to have the defendant present his own version of an EED defense?
Well, in most cases, in 99 out of 100 cases, the people really will not be surprised that the circumstances of the crime, the nature of the crime, the statements the defendant has made post-arrest, the testimony of other witnesses will alert the people that this is going to be an EED defense.
I mean, often the people won't know. Sometimes the defendant won't know whether the defendant is going to decide to take the stand until after the people rest. Isn't that
But
true?
that's the nature of, I mean, the defendant doesn't have to decide whether to take the stand, whether to testify on his own behalf till he's heard the entire people's case.
He doesn't, and whether he could be constitutionally required to, he obviously isn't normally required to give notice of whether he's going to testify. But is there anything unconstitutional about saying if you're going to testify in support of a particular statutory defense, you've got to tell the people in advance?
Well, it is if the failure to give such notice is that his defense is barred in toto, which is the way
But in this case, that's not really what happened, right?
It's not what happened in this case.
In other words, what's the harm? We know what happened. So there was a psychiatrist on that side. He went and got his own psychiatrist. What's the harm? He wasn't barred from putting in the defense, right?
Not here. But this Court is the final arbiter of the law in this case and has to be aware of the ramifications in other cases. And certainly the appellate division rule was that if a defendant doesn't give notice, it can be barred entirely. And the Court allowed late notice here.
But in our particular, I hear what you're saying. Was there did it inform the fairness here that the judge's ruling?
Well, what happened is that the judge required the defendant to submit to an examination.
Right.
And the testimony that resulted, I mean, an entirely different trial took place here, which was
But why wasn't that, but still from an equity point of view, was that not fair to the defendant?
That we would argue that it was not fair to the defendant.
Why? What's the harm?
Well, he had an opportunity to put in his own psychiatric evidence, including a psychiatrist. So,
He did. Well, that was clearly a defensive measure here, but he had to submit to a prosecutor. The trial became dominated by the testimony of an expert who
that's
gave
because he
highly...
gave credibility testimony.
Yes, which
gave
I would like to address later.
Right. That's the prejudice here, possibly, not the fact that he didn't give notice. He was allowed to put in a late notice. He was examined. He was allowed to bring his own psychiatric evidence. If he didn't, then the people would not have been able to use their psychiatric evidence that they had acquired. So I think what the court did here was just give everybody a chance to litigate this issue. Which
I apologize. I read it differently. I read that whole section as a notice with respect to a mental disease or a mental defect. And as I understood it here, the defendant was not saying either one of those things. He didn't say, I don't have a mental disease, I don't have a mental defect, but when my girlfriend said what she said, I blew up, and I got very emotional, and I ended up doing what I did. That's not a mental disease or defect necessarily, and as I understood the defense here, I want to tell the jury that. And for the people to then say, well, what we're going to do is get a shrink that's going to say you do not have a mental disease, you do not have a mental defect, is irrelevant to the EED defense in this case. Isn't that true?
Yes, Your Honor. I would agree with your description of this, and I think that there's an overstated...
Is EED limited to mental disease or defect?
Well, it is a mental infirmity.
It's emotional disturbance, isn't it?
Extreme emotional disturbance.
Extreme
It arises-
emotional disturbance.
It's a little broader than the old heat of passion, but I think it would surprise, it had never been contemplated in the past that you had to have expert testimony for the normal EED defense, that there's really been an overstatement here of the prejudice to the people if they don't know later.
So lay testimony doesn't create any problems, really, for the prosecution?
No, I mean, for the prosecution, I mean, they can attack it. I mean, they're really at an advantage if the defendant only puts on lay testimony and support. The defendant might not get the charge. The jury might not feel, even if it gets the charge, that the evidence...
But in terms of fairness, are you arguing that it doesn't create that issue in terms of the prosecution?
Not create
because
undue
it's lay
fairness.
testimony about just what his feelings were,
Yes,
what
and-
overwhelmed him or whatever it was.
And
What if the
people can-
prosecution wants to present some mental health expert to testify? How would they know that the defendant is going to present lay testimony if you don't require the notice?
Well, in many, I mean, this comes up with justification, comes up with lots of defenses, and the people are able to adequately rebut it by cross-examination, by calling lay witnesses. Here, the witnesses, the lay witnesses they used in rebuttal were interviewed by the police before the defendant was ever arrested, that you wouldn't need expert testimony to rebut.
That may not be true in every case, though. There may not be
Well,
other
there may be a
witnesses.
small, well, in that small fraction of cases where the prosecution is genuinely surprised and at a disadvantage, they can ask for a brief continuance. There are certainly federal cases that talk about preclusion of the defendant's testimony being too great a sanction for a lack of
But
notice.
is it really that uncommon that a defendant will say, I heard this, or I learned this, I got this information, I suddenly went wild, I was transformed by the news, I wasn't myself, I was extremely emotionally disturbed. It's legitimate, isn't it, for the prosecution to call a psychiatrist to say, no, on the contrary, this man was acting totally in character, he's a psychopath, this is what he does. This wasn't an extreme emotional disturbance. This was the normal course of events for this man. Isn't that a legitimate response by the people?
I don't know if it's a necessary response. We talk about the legislature enacted this to prevent undue prejudice to the people. And our argument is that the people are simply not, when a defendant's only evidence in support of his EED defense is his own lay testimony that explained what happened.
But he might be able to do that very plausibly. You could imagine a defendant who tells a pretty good story about I was a fine, upstanding human being until this day when this horrible event drove me mad.
Yes.
Wow, isn't a completely appropriate rebuttal to that a psychiatrist who examines the defendant and says, no, he's not who never was a normal, upstanding human being. He was always a violent, aggressive predator.
Well, I would disagree with whether that kind of testimony is really appropriate. This particular expert does tend to give testimony that it's part of his character. It really seems like propensity evidence.
I have some problems with the expert's testimony too, but I didn't have so much problem with the part where he said this was not out of character, this was in character. Don't you almost have to make that judgment if doesn't the jury have to figure out whether it's out of character if the defense is extreme emotional disturbance?
Well, the defendant, first of all, what we have to remember, one thing is that this is the defendant's burden to prove by a preponderance of the evidence that he experienced extreme emotional disturbance and that there was a reasonable cause for it. It's not, this statute, and one thing we have to remember is it grew out of the desire to protect the people who had the burden of sanity, and defendants could spring an expert on the prosecution, and the prosecution had no right to examine. Our argument is that really there isn't the great need in this case, and first of all, I don't think you can separate that the notice provision as it's been interpreted. You start with whether notice has to be given, and it may not have happened to this client, but the people are arguing that a defendant who doesn't give notice isn't allowed to testify about his responses and his reaction, and the Court certainly has to address whether the statute applies to him in the first place.
So in your situation, you see as the typical way this would unfold, that he's giving lay testimony, you cross-examine him, end of story. There's no need for...
Well, sometimes, yeah.
I mean, in general.
Yes, that the prosecutor, that's the way our adversary system works, and a defendant brings up self-defense, and the people have to meet it when they hear it. Sometimes trials start as a justification and they end up being
So
EED.
without, in the most common sense way of looking at this, you're saying without a medical affirmative defense or testimony about mental illness, he just comes in and, like in any other case, says what happened.
Yes.
Is all that's happening in layman's terms.
I mean, that's generally...
And then you cross-examine him. That's the way these things work. This is not complicated by the statute or its requirements or anything else.
Yes, Your Honor. I mean, as Justice Pickett described it, although that language is in the statute about mental defect, it's really imported from the insanity.
Well, that's the point.
And it's not...
Is
and it
that
wasn't
what's
intended.
going on here? That
No.
This is all imported from the insanity defense, and...
It doesn't really apply.
It doesn't really apply here.
It is a mental infirmity defense, certainly, but it's not like insanity. And in insanity cases...
I don't want to interrupt, but at some point, will you address the credibility point? I don't want you to run out of time.
Yes, Your Honor. But what happened here, I mean, is really going to turn garden variety...
Didn't this come up in a very unusual way? Didn't it come up in the context of a Molyneux application in any event?
That the defendant...
I mean, we could assume, could we not, that this defense would never have been made known prior to the people arresting if it hadn't come up in the context of this Molyneux inquiry.
Well, I think the circumstances might have... Generally, the defendant does not have to tip off the prosecution
That's the point.
or have to decide before the trial starts. He can think he's going to raise an EED and listen and think, well, they really haven't proven that I did it or I did it intentionally.
Well, and then this extreme emotional disturbance is extreme emotional disturbance at the time of the incident, not subject to be examined later in the light of a psychiatric review. Would you agree with that?
Yes. Yes, Your Honor. And what happened here is that we had an expert who not only testified at great length and whose rebuttal testimony was substantial, but he testified that the defendant's version of the events was as probable as the moon being made of Swiss cheese, that he was perjuring himself, that the deceased had told the truth about matters.
Didn't he go beyond the scope of what the judge had let him do in the motion in limine, or at least wasn't, I mean,
But most of it, he did go beyond the scope.
shouldn't defense trial counsel have been on his feet screaming when the witness did that?
Well, most of what was, I think, really prejudicial was violated what, I mean, defense counsel did exactly what he should have done. He made an in limine motion. He attached the report. He talked about specific aspects. He said there should be no credibility testimony. And the expert may not give the longstanding rule in this state that he must not give credibility.
Okay, but the judge said, the judge made a one-line oral ruling that says he can express his opinion as to whether he believes that the man in fact got this bad news on this occasion.
Right, and not general credibility. There was only one sentence.
But it seems to me that ruling in itself could be right, even though, well, you may be right that what the expert in fact did was a little excessive.
Well, the defense counsel had moved specifically that there shouldn't be any testimony about the defendant, about the defendant's truthfulness.
The defense counsel asked for a million things, and the judge ruled on one narrow issue. Isn't that a fair summary?
No, did not rule on one. He said he applied a rule that the Second Department has carved out that an expert may testify about his perceptions of the defendant's truthfulness, but not general credibility. There was only one statement which one bit of his testimony talked about general credibility. For the rest of it, it was his credibility about the events.
Okay, counsel. You'll talk more about it on rebuttal.
Thank you, Your Honor.
Good afternoon, Your Honors. My name is Shulamit Rosenblum-Nemec, and I represent the respondent.
Counsel, what about the expert? It does seem excessive, to say the least, you know, in terms of the comment. Isn't the expert replacing the fact finder in this case?
No.
Why not? What about the man in the moon and all those kinds of things? Why is that not moon made of cheese and all this stuff? Isn't it really mocking the defendant?
I don't dispute that this expert went farther than he should have.
Even if we accept Dozie or whatever the case is,
Right.
Doesn't this go way beyond that?
Well, the point is that the court ruled only that he could talk about his own perceptions of what the defendant
but
was
did he?
telling him. And if this witness went further than that, it was up to the defense attorney to jump up and say, I object. And the court, as a matter of fact, whenever
So he went too far, but the defendant didn't object?
Correct.
Is that
It's
your
not
argument?
preserved.
You acknowledge he went too far?
Oh, yes.
Okay.
I mean, there were places where he said that it would be perjurious or that he was an expert in
Right.
lying. And the court intervened and said, members of the jury, it's up to you to judge credibility. This person is just expressing his opinion with respect to the things that he relied on.
Shouldn't the court have gone a little? Shouldn't the court have said the jury will disregard that?
Well, if it had been asked to, it certainly should have. Having not been asked to, I think the court did as much as it felt necessary at the time. And why the defendant didn't ask for more specific curative instructions and didn't object timely, I don't know. But the court did what it could to try to rein in this expert. And in the end, if one looks at the totality of the case, this expert's contribution beyond what was entitled really didn't make a difference to the case.
Well, it wasn't the effect of it to give the prosecution an extra summation.
It gave the effect of emphasizing certain aspects of the prosecution's case, but the prosecution's case, if the expert hadn't even testified, would have been very strong. And this is an unusual case because it's a murder that has witnesses, eyewitnesses to the actual murder. We have a history between the defendant and the victim that was known to the courts and medical records, and the defendant was foolish enough to start discussing plans to murder his girlfriend with his prison mate and tried to enlist him in a reciprocal murder plot. He actually said that he was going to strangle her if he got out.
But what about counsel, the other main issue in the case, that He just wants to give his lay testimony as to what happened, what his feelings were. Why doesn't he have a constitutional right to do that?
Oh, he has a
I
constitutional...
mean, without taking away the whole affirmative defense, yeah.
Well, this Court, in a trio of cases, in Burke, in Roach, and Almanor, basically said the following, that you cannot prove you can't establish an extreme emotional disturbance defense without evidence that the defendant acted under a mental disease or defect, a mental infirmity that doesn't amount to insanity. And that is the precise evidence of what psychiatric evidence is under the statute.
Does that mean that when he said, I want to use an EED defense and I'm only going to use lay testimony, that the judge would say, then you don't get an EED defense?
You won't get an EED defense unless you offer psychiatric evidence. But the psychiatric evidence may consist of lay testimony.
Well,
he doesn't have to offer a psychiatrist, but if it's addressed to the question of whether he acted with a mental infirmity, whether it comes from the defendant or whether it comes from another lay witness, that is still psychiatric evidence. And it's just as hard for the people to answer that, whether it comes from a psychiatrist or a lay person, because the people will not necessarily have notice from the evidence.
Well, let me give you an example. I've been trying to think of a decent example for a week. But let's assume that you're a Buffalo Bills fan and they actually win the Super Bowl, and you're so damn excited you back out of your driveway and you run over your neighbor. And now you're charged with criminally negligent homicide. And you go in, and I guarantee you in a Buffalo jury you can win with this. You say, it was the Super Bowl, we won, I was just I was just so excited, it was a total accident. I think I'd get acquitted. Now, I guarantee I'd get acquitted. Did I introduce extreme emotional disturbance testimony there that would require you to give you notice of it so you can get a doctor to say, we've examined the defendant and he really is not, or he's not nuts, or can I simply say that and let a lay jury, make a determination as to whether or not in the emotional state the defendant was in, it wasn't a crime?
Well, the short answer to that is that it's not an EED defense at all, and it's not a mental health defense.
But isn't that what he was doing here?
What the defendant is saying in the case that you posit is that I was so excited I acted negligently.
Isn't that what he's saying here? He's
saying that I did it, I intended to do it, but she said something to me that so upset me, that so dislocated me from my rational self, that for that moment I was arguably something like temporarily insane. Actually out of control is really what the essence of the EED defense is.
How do we know when it crosses that line between what Judge Piggott is talking about and what you're saying? You believe that's different, right, the hypothetical?
Absolutely, because Judge Piggott's example is basically saying I was negligent and this was the reason that I was negligent. It's not saying we wouldn't have charged the defendant with murder in that case if we thought that if we thought he did it intentionally.
No, that's why I say it's criminal negligence, and I'm saying no, it's not. And I explain it in my lay terms. Do I get precluded from doing that because you're talking about a mental disease or defect that you didn't give the people notice of?
Yeah, that's not a mental disease or defect. What you're talking about is a momentary piece of excitement that doesn't rob you of your rational, your ability to reason. I mean, it could be that you could make a mistake.
If a defendant,
you could be not as alert to your surroundings.
If a defendant said, I walked into my bedroom, there's my wife in bed with another guy, and I shot him.
Yes.
Has he raised an emotional defense that requires him to give you notice so you can have him examined by a psychiatrist?
Yes. If he's trying to say
that... But if that's all he says, even if he doesn't...
If he says that and is asking the jury to consider that in support of an EED defense, yes.
Okay, well, but there's I should know this. Is EED a defense for any purpose other than knocking murder down to manslaughter?
Not to my knowledge.
So really, EED doesn't exist outside the murder context.
It doesn't exist outside the murder context. There are other mental infirmity defenses that do. For example, a person can say that I was unable to form the intent, a kind of diminished capacity, perhaps under the influence of certain kinds of medication or a certain kind of illness or some other way of either mitigating or reducing responsibility for criminal
But
conduct.
now, I asked you before, how do you know the difference between when I'm just testifying and it becomes EED? No, in all these situations, person just comes up, wants to testify and tell the story. You mean in the middle of the point where he's telling the story, the label, the lights go on, EED, defense, and then we have to get the shrinks and he should have given notice. How do you know? As opposed to just, I want to tell my story.
Well, first of all, the lawyer who prepares his client to testify at the case should be able to tell whether his client is offering something that looks like EED or not.
It's always so clear.
It's difficult for me to imagine a case where the defendant has any hope of succeeding where it will not be clear.
Well, if a defendant doesn't ask for an EED in jury instruction, would
Then
you
it
need
doesn't
to give
matter.
notice?
No, then it wouldn't matter.
So he could give whatever recitation he wants to give, as long as he's not asking for the
Right, and
charge,
if it's
correct?
not in support of an EED defense, that is to say, asking the jury to consider it as mitigation, then he can say whatever he wants, but obviously what
he
he
would
did
still be
be
putting it
doing
before the
is
jury.
admitting to having committed a murder while he was upset, but that's not going to mitigate his criminal responsibility.
So what they should have done here, what the court should have done is simply say, do what you want, but you're not going to get an EED charge if you don't have some testimony.
Well, the court could have done that.
Because it seems to me troubling that a court would order a defendant to do almost anything. I mean, you know, the cloak of innocence is such that, I mean, as he was sitting there, he's not guilty of a darn thing. And you got a judge saying, you got to go see a shrink.
Well, Your Honor, I think the legislature made it pretty clear that when it comes to these defenses, these psychiatric defenses, the price of being able to raise that is that you have to see it.
But see, I looked at it as if the defense says, I've got a doctor that's going to come in and say this guy's nuts. They've got to tell you. But if it's just your normal garden variety case like apparently the defendant wanted to use here, he can do that. And then when he asks for an EED, if you make the argument you're making here, which is that there's insufficient evidence of an EED defense, then he doesn't get it.
Well, he shouldn't get it whether they're sufficient or insufficient if he hasn't given notice in advance. Because
Once he puts it in issue, once he puts his mental state in issue, then it's open. It's open. The court can order him to have a psychiatric evaluation. The court can give the people an opportunity to get their own psychiatrist.
Once he puts in a claim of mental infirmity, I mean, mental state can mean a lot of different things.
What's the significance of the words mental disease or defect in the definition of psychiatric evidence?
Well, they mean a mental infirmity not rising to the level of insanity for the purposes of
So
EED.
you take those terms to be interchangeable?
Yes.
Was
And if you
it
look at-
essentially a drafting error they didn't say that?
Well, it may have been a drafting error originally, but if you look at Burke and Almanor and Roach, this Court has repeatedly said that, well, yeah, it was originally linked to insanity, but now it's clear that what we're talking about is any psychiatric defense.
So you'll stick to EED for the moment. Your view is that it's essentially impossible to present an EED defense without triggering the notice statute.
Yes. And I think that's the legislature wanted that for a couple of reasons. One is that you're not always lucky enough, as we were in this case, to have lay evidence that contradicts it or evidence from an eyewitness. If this case had not involved the daughter having witnessed the crime and the defendant having spoken about it ahead of time to his cellmate, we would have had a dead body and a defendant's story. And we would not have had any idea necessarily before the trial occurred what his defense was going to be.
Let me give you another hypothetical. Almost the same thing. You've got a dead body, and you got a defendant, and the murder happened, or the homicide happened at night, and you go through your thing and do whatever you do, and then he gets on the stand and says, "Yeah, I shot her, and I shot her because this is what happened. She came after me with a knife." And I took the knife away from her, and comes up with this whole concoction. I mean, you can't say surprise.
No, but that's because we ordinarily, in the case of justification, ordinary lack of intent, accident, all of those ordinary defenses, the prosecution's case is usually geared toward disproving that.
Right,
We
but
would be trying to disprove that on the basis of the physical layout of the crime scene, or of the defensive wounds, or the force that it took to kill the person, or any kind of the physical evidence at the crime scene, the autopsy, a lot of circumstances.
If you have a case of a defendant who shoots through the door and kills somebody, and he said, well, I did it because I was scared and I thought that was my ex-husband coming, and it turns out it wasn't, or whatever, is that an extreme emotional disturbance? And do they have to give you notice so you can have a shrink look at him and say?
No, because I did it because I was scared is usually a justification defense. Whether it's reasonable or it's not reasonable, that's something that a jury can decide based on those circumstances.
Why couldn't they have done that here?
Well, because what the defendant is talking about is saying, I was acting under a kind of mental infirmity. He doesn't call it that, but I went crazy is basically a lay term.
But in the
or a
final
lay way of
analysis,
referring-
isn't it a jury question as to whether or not the defendant was affected by extreme emotional disturbance?
Oh, absolutely. Absolutely.
See, what strikes me is what Judge Jones said earlier. I mean, this wasn't even on the radar screen until you made a motion for on an evidentiary matter. Otherwise, you'd have gone forward with this. He'd have done his thing, and
Well, we would have jumped up and down in the middle of trial. We would have had a mistrial. We'd have to
Think so?
start all over again.
So what happens then? So let's say he starts to give his story, and you say, the light goes on, EED.
Right.
What do you do? Yeah.
Well, there are a couple of things. One is
He thought he's just telling his story, and
Telling his-
which is his right, he thought. So what happens?
Well, a couple of things could happen. We could jump up and say, Your Honors, we've been prejudiced. We had no idea that he was going to tell this story about being mentally disturbed, and we want a mistrial because we have not had any opportunity to examine this defendant.
Well, he can tell any story he wants, can't he, as long as he doesn't ask for the EED charge?
That's true, if he doesn't ask for the EED charge. But if we're going to assume that he's telling this for that purpose,
So your first, the first thing you do when you when he starts telling his story is you say, Judge, I don't know what this is for, but if it's in support of an EED charge, he was supposed to give us notice.
correct. And because if he doesn't ask for an EED charge, then whatever he says about what was going on in his head
Then
is not going
he's
to make
really
a
just like the
difference.
Bills fan. He's trying to get the jury's sympathy.
Yeah, but that's not going to help him when it comes to deciding whether he committed murder. It's going to be...
Unless the jury's sympathetic.
Well, there's always the possibility of jury nullification. Judge Jones, you earlier mentioned that we're talking about the defendant's state of mind at the time of the crime and not at the
Yes.
time that he's examined.
Yes.
But in the case of insanity or EED or any of these mental defenses, it's always a question of what the defendant's mental state was at the time of the crime, and we're always looking backwards at what they did, no matter what circumstances we're examining him under.
But what
we're
I'm-
always trying to figure out after the fact what it was that was on his mind.
I know, but what I was suggesting is that a subsequent psychiatric examination may not be helpful to making a determination as to how a person's mental function was at an incident 6 months before or a year before.
But that's equally true of the insanity defense. It's true of any defense where the defendant says, this is what was my mental state at the time I committed this crime. We're always having to reconstruct it on the basis of what the psychiatrist can learn from speaking to the defendant, from reading all the information about the case.
Ms. Nemec, could you though see, I'm thinking, as the case goes along and the defendant realizes, the only defense I've got, is that I was out of my head at the time. He could choose to do that late in the, after he watches your case being built and realizes that his alibi defense is gone or whatever else, and says, this is how this happened. And are you suggesting that that's a mistrial every single time?
It may not be every single time, but it will often be, because unfortunately for the prosecution to be able to answer that adequately, assume he makes a real EED defense. He suddenly decides that the only thing I have left is EED. There is no way for us to prepare to evaluate his background, his school records, his military records.
Well, that's what makes
his
me think.
psychiatric records, or even to have an expert ready to look at his test, to be there and watch him testify.
That's what makes me think that 250 was always a doctor-to-doctor disclosure. You know, almost like the alibi defense. You got to tell me what your alibi is, and then to give us an opportunity to go and prove that you weren't there, or that your alibi witnesses are the same ones you used the last time, or whatever. But it's to keep things fair. So if they're coming in with a doctor, you get to get your own doctor, and that's the end of it. But you're saying it's much broader than that.
It is much broader than that, because even if they don't come in with a doctor, we still have the burden of disproving that EED defense. The defendant may have to prove it only by 51%. That means that we have to disprove it by 51% if we want to keep the conviction. And he's the only person who knows what's been going on in his head with respect to whether he's sick or not. There is no objective evidence under normal circumstances.
But that's true of justification. That's true of self-defense. It's true of many of them, isn't it?
That's true. It's true of the ordinary defenses, but in the ordinary case, we can rely upon the circumstances of the case to prove
Why isn't
that the person acted intentionally.
why isn't cross-examination sufficient?
It's not sufficient because the defendant has every motive to obfuscate and to lie.
He's
and
not
he
a
might
doctor. He's just telling a story.
The defendant could be an extremely clever person, or he could be a not very clever person.
Some of them are innocent. I mean, don't say every defendant has a motive to obfuscate and lie. I mean,
No.
maybe he's telling the truth.
This one certainly did.
Well, I'm just suggesting that if we're making a broad rule.
No. But what we're saying, but in a defendant who's claiming EED is not innocent under any circumstance.
He's telling a story.
He may be telling a story, but let me just qualify this for a second. A defendant who's claiming EED is admitting that he committed murder. All he's saying is, I had a reason for making myself less criminally responsible than the ordinary murderer. So there's no question whether the defendant was innocent or not. As far as just telling his story is concerned.
Go ahead. Finish your thought. But
as far as just telling his story is concerned, the people have the right to have the story told in an orderly fashion that they can respond to. The defendant does not have an absolute right to testify to whatever he wants to in whatever order he does, because the State has the right to limit it in a reasonable, non-arbitrary way and to try to promote the efficient reception of evidence of this sort.
Okay,
and
counsel.
for all of those
Thank
reasons, we ask that the lower court's decision be affirmed.
Thank you, counsel. Counselor Rebuttal?
Yes, Your Honor. Can I just ask you one thing? Going back to Dr. Berger's statements as to the defendant's credibility, your adversary seemed to suggest that the defense counsel should have been jumping up and down and objecting as the testimony was coming in. The defense counsel did make a mistrial motion before the motions to dismiss, correct?
Yes, Your Honor.
And the trial denied that and offered a curative instruction in its place, correct?
Yes, Your Honor. And the initial motion, the fact that the judge just denied it the defense application, which was highly specific and said there shouldn't be testimony about the defendant's credibility, about his guilt, about the paternity of the child, and attached and cited specific aspects of the testimony. That was sufficient to preserve it when it was denied. Our argument really isn't, except in maybe one or two comments, that the expert exceeded the scope of the ruling. Our argument is that that ruling was incorrect and that the appellate division applied that the court below and the appellate division applied an incorrect rule.
So you could prevail on that issue alone, because the people could prevail on the issue of notice, and you could prevail on the issue of the testimony of Dr. Berger. Is that correct?
Well, there are independent issues, but certainly it shows what can happen, what happened and how the defendant in this case was prejudiced, even though he was not deprived of what is his absolute right to testify about, in full, about his feelings and his thoughts.
Counsel, but what about your adversary says that if you want an EED charge, you've got to give notice, period.
No. Well, Your Honor, I've been doing this a long time, and I've seen
So
plenty of
explain
EED.
why that's not the case.
Well, there have been plenty of EED cases back to the 80s after the statute came into effect. I've been up here on EED cases before this Court where after the statute came into effect, there were There was no notice, no expert. The prosecution had no problem in rebutting the defense.
And you
There
got-
was no
and you-
right to a mistrial.
You got a charge in those
And there were
cases?
charges. We fear that because of this case, that it's going to encourage judges to require examinations and make every case
So
like this.
what's the rule going forward? Where do you draw the line?
I'm sorry.
Where do you draw the line? When do you have to give notice?
You have to give notice
If it's
you're
lay
calling an
testimony, never?
expert. If you're calling an expert,
Right, if there's lay testimony, you just don't, period.
you don't. And they've
Wouldn't
always
it
been
have
able-
been easy for the legislature to say that? I mean, they know how to say testimony by a psychiatrist or psychologist. They said it in another subsection of the statute.
Well, they said psychiatric testimony, psychiatric evidence, and we say it's easy to say that
Then they define it. I mean, an obvious way to define psychiatric evidence would be evidence by testimony by a psychiatrist or psychologist. They used words that look broader. Why did they do that?
Well, they also use language that was clearly a mistake. It's not a well-crafted statute, and it's also sort of a piecemeal statute that's changed over the years, that's been amended to extend to EED, that's imported language that has only been used in the past for...
Can I just ask you, no one's asked you about post-homicide behavior, because in this case, I suppose on cross-exam, they could have challenged the fact that he had the wherewithal to steal a radio and CDs, and that kind of negates what he was claiming. But in a situation where perhaps the person charged with the homicide has engaged in post-homicidal behavior that they want to use an expert for to explain that shows that the person did not experience a lack of control,
Well, here actually...
that would be foreclosed if you don't have the notice.
Well, here actually, as I recall, Dr. Berger testified that it did not foreclose EED.
I know, I'm saying if you had a different fact situation,
Well, here...
there could be a need for the people to bring a psychiatric expert in, even with lay testimony.
Well, here the post-homicide actions were bad, that he ran away, that he had the wherewithal to find a place for his children, but the expert for the prosecution nonetheless testified that it didn't foreclose it, so that didn't help them.
Okay, counsel. Thank you both.